It's on this morning's docket, case number 113929 in the matter of George Thomas Williams.
May it please the court, counsel, Deborah Hughes with the Disciplinary Administrator's Office. I'd request permission to reserve 3 minutes for rebuttal.
3 minutes is granted.
This is an original action involving attorney discipline. This case is before the court after a hearing before a hearing panel. The hearing panel heard evidence in this case in January 15 of 2015. The respondent in this case signed a stipulation to the facts and admitted the rules violations that were charged in the formal complaint. After the hearing panel found that the respondent violated the following rules. That would be KRPC 1.3, that's diligence. The panel specifically found that Mr. Williams was retained by Ms. Simmons to represent her on a case against Commerce Brokerage Services, and that in the course of that representation, he failed to take any action whatsoever on her behalf on that matter during the 20 months that she was his client. The panel also found a violation of KRPC 1.4, that's communication. The panel found that Mr. Williams failed to return Ms. Simmons' telephone calls and email messages during the course of the representation. The panel found a violation of KRPC 8.4c, that's conduct involving dishonesty, fraud, deceit, or misrepresentation. Specifically, the facts that supported that rule violation were the following: that Mr. Williams fabricated the April 3, 2013 disengagement letter to Ms. Simmons that he submitted to this office, the Disciplinary Administrator's Office, after he received the disciplinary complaint that was filed by Ms. Simmons, that he fabricated a note dated April 3, 2013 that purported to reflect a telephone conversation between Mr. Williams and an individual at Commerce Brokerage Services, and submitted that to the Disciplinary Administrator's Office as part of the investigation. That he falsely told the disciplinary investigator that he had mailed that fabricated April 3, 2013 letter to the complainant. He testified falsely during the sworn statement that was taken by the Disciplinary Administrator's Office, and that he testified falsely at the panel hearing. The hearing panel also found a violation of KRPC 8.4d, that's conduct prejudicial to the administration of justice, when Mr. Williams failed to take action to represent Ms. Simmons and when he engaged in the conduct that I just described. The panel also found a violation of KRPC 8.4g, that's conduct reflecting adversely on fitness to practice law. The panel found that Mr. Williams obstructed the disciplinary investigation by fabricating evidence, testifying falsely under oath during his sworn statement and at the disciplinary hearing before the hearing panel. Finally, the hearing panel found a violation of 8.1a and Supreme Court Rule 207b. Both of those rules relate to the duty to cooperate in the disciplinary matter. Mr. Williams failed to cooperate in the disciplinary case by fabricating documents, submitting false evidence, and submitting false information to the investigator, and by testifying falsely. The respondent did not file any exceptions to the final hearing report in this case. So the primary issue before this court then is, what is the appropriate discipline? The recommendation that this office made before the hearing panel was for disbarment. The hearing panel noted that disbarment was the appropriate discipline under the standards, the ABA standards for attorney discipline. However, the hearing panel recommended indefinite suspension. They did so without explanation, really, as to why they were differing from the ABA standards.
I was just gonna ask what the mitigators were supposed to be that resulted in the recommendation from the hearing panel, if you were aware.
The only mitigating circumstances that the hearing panel found were the character reference letters that were submitted on Mr. Williams' behalf. They did not find remorse. They specifically found that the respondent did not appear to be remorseful for failing to properly represent Ms. Simmons or for engaging in dishonest conduct. They found that although his personal or emotional problems mitigated his conduct as it related to the diligence and communication issues, there was no connection between his personal or emotional problems and the dishonest conduct, which it's the dishonest conduct that under the ABA standards is what triggers the disbarment as the appropriate discipline. So other than the character and reputation letters, that's paragraph 45 of the final hearing report, there are no other mitigating circumstances. And on page 23 of the final hearing report, paragraph 50, the panel does not explain what factors it relied upon to differ from the ABA standards for disbarment.
That was my observation. You mentioned when you first stood up that there was a stipulation entered into or signed before the panel hearing, but the panel's ultimate determination that the respondent engaged in dishonest conduct during his testimony at the panel hearing had to do with him backing up from some of those stipulations, correct?
That is correct.
Okay, and is your continuing recommendation today for disbarment?
Yes, it is. Nothing has changed. The factors that supported that recommendation at the hearing still justify, in the disciplinary administrator office's opinion, disbarment in this case. The standards under the ABA guidelines support disbarment, and as I argued at the hearing, we have a demonstrated pattern of neglect and failure to communicate in representing clients. We have 2 prior disciplinary matters in which Rule 1.4 was at issue. And most importantly, I think what we have here is that Mr. Williams has demonstrated that when he is called upon to answer for his misconduct, he resorts to deception. And he did so repeatedly throughout this case. He did so from the get-go. He did so when the complaint was first sent to him. He did so when the investigator contacted him. He did so when he sent the response to our office. He did so when we asked him for his sworn statement, and he did so when we asked him to produce his attorney-client file, and then he did so at the disciplinary hearing. The lawyer's duty to cooperate in the disciplinary process is the cornerstone of our system of self-regulation. He obstructed that process, and he engaged in dishonesty in obstructing that process. And he fabricated evidence in an effort to make it appear that the complaint was meritless, and it was not a meritless complaint. And this conduct demonstrates that Mr. Williams cannot be trusted to participate in this process of self-regulation, and that he cannot be trusted with the privilege to have the license to practice law.
There was
Yes.
as a result of the representation, you said it wasn't a meritless claim. There was a loss of $20,000, or at least a tax claim of $20,000. Is that right?
I believe it was approximately $50,000.
Okay. And has that ever been resolved, or do you know?
Ms. Simmons had representation and was able to obtain a settlement on the case against Commerce Bank. And it's in the transcript. I do not recall off the top of my head what that settlement was. I believe she ended up, after attorney's fees, I want to say with approximately $7,000. That might be a few $1,000s off. That was her portion of it.
And was the $50,000 that was obtained and then the $7,000, was that impacted by the delay of 20 months? Or do you know the impact of at least the diligence aspect of the case?
I am not sure. I would have to look through the transcript. And I can review that and answer that if I can on rebuttal.
But there was no like restitution ordered or any kind of claim for money that was owed?
There was not.
Okay. Thank you.
The panel found that the respondent's testimony before the panel was false.
Yes.
The final report, however, doesn't indicate whether that was sworn testimony. I'm going to assume that it was sworn testimony. Is that right?
That's correct. And that was based on the difference between the stipulations and his admissions to each of the numbered paragraphs in the formal complaint and his answer where he admitted, and then the testimony that was given under oath at the hearing that was different from that.
And by the same token, can you elaborate on what the sworn statement looks like you were talking about during the investigation itself?
The sworn statement that was given,
I don't need to see it, just what does that entail?
that was our investigator and I went to Mr. Williams' office to take his sworn statement. Particularly, I was interested in asking him questions about the April 3 letter.
But how do you do that? Are you taking a court reporter
Yes,
or you
we-
ask? All right.
Yes, I'm sorry,
And
we had a
then-
court reporter.
Then the respondent is sworn and in these situations answers your questions.
Yes, he
And
was
it's-
sworn
All right, thank you.
by the court reporter.
All right, anything else? Thank you, counsel.
Oh, I lost this, Mr. Ambrosio.
John Ambrosio, on behalf of the respondent, Mr. Chief Justice, Your Honors, may it please the court.
Mr. Ambrosio, when did you become involved in representing your client in this case?
After the formal complaint was filed, the pleading was filed, I think about a week after that I became involved. Got an extension of time to answer the final complaint. He admitted in the formal complaint his transgressions and then signed the stipulation.
Thank you.
There's no doubt that my client improperly represented somebody during the course of that earlier action. There's no doubt that he was not diligent. There's no doubt that he was incompetent in the way he handled that file. He was not diligent. He did not handle that claim properly. As a matter of fact, if he'd been smart, he would not have taken that claim. And if he had acted properly during the investigation, we wouldn't even be here now. He would have admitted his transgressions. He would have received some type of discipline, perhaps a diversion or something more than that. Or even if he had had a hearing, if we were only dealing with that claim, the underlying claim, he probably wouldn't be here trying to save his license. There's no doubt about that. Everything came together, and he did this without representation, without talking to a lawyer. He answered the complaint, the letter complaint, by himself, and then when the disciplinary administrator's office showed up with a subpoena and wanted to talk to him and take his statement under oath, everything came together. His emotional problems, his business problems, his financial problems all hit at once, and he became panicked and he became scared. We're not excusing his behavior, but that's exactly what happened. And that's why when that came out during the course of the hearing, when I made that argument, I believe the panel thought that he deserved something less than a disbarment. I'm convinced of that, although they did not allude to it. Not that I'm patting myself on the back that I'm such a great lawyer or a great advocate, but I think they bought into that during that time, and that's
Mr.
why it
Ambrosio,
was less than.
are you saying that his sworn statement was inaccurate and that, in fact, the testimony he gave before the panel was truthful?
I am saying that his sworn statement was inaccurate, and I think he tried to answer before the panel correctly, became confused, and it was inaccurate.
Okay,
That's what I'm saying.
so this is what confuses me. Why did you not take any exceptions to the finding that your client lied under oath to the hearing panel?
Because when I discussed it with my client, the decision was made not to make exceptions.
Well, you're stuck with that now, aren't you?
Correct, yeah, absolutely, and I'm not arguing against that.
Well, you just, except that you just argued that his testimony was confusing and mistaken. It wasn't false.
I don't think I'm limited in my argument.
Okay.
I don't think I'm limited. And I made that argument that you're absolutely correct. I'm not limited in that argument. It was a perfect confluence of factors in this case. What he did was wrong. What he did, he's sorry about. He was remorseful. He just doesn't have the persona that looks like he's remorseful. He just doesn't have the persona that shows that he's sorry about this. And I think what happens in these type of cases, you get a complaint and you panic. Instead of those who are involved in this all the time, we say, you're better off fessing. You fess up, you tell the truth, everything's going to be okay. He was unable to do that. If he had gone to a lawyer, if not me, somebody else, the lawyer would have said, admit you did something wrong. It's obvious from looking at the file you did something wrong. We never would have been here today. Because of his situation, he was unable to do that. At the time, my client ordered me to ask for a public censure. We now are asking for a 1-year suspension, not a disbarment or even an indefinite suspension. He's 58 years of age. He'd like to come back and practice after 3 or 4 years. His life is basically over. His career is over. He's never going to have any clients. He's in the process, because he's a decent man and a smart man, of closing down his practice, advising his clients. He's not taking any more cases. He's going to close his doors down. He understands what's going to happen. He's not a fool. All we're asking for is that there be lesser discipline than a disbarment.
And tell me again what that was, I missed it.
1-year suspension,
Thank you.
a finite suspension.
Well, you know, you're saying that this was a confluence of things that occurred when Ms. Hughes showed up with the investigator. The purported letter was submitted in January of 2014, and the interview didn't take place till well after that.
Mr. Justice Rosen, I'm saying it all happened over time. His emotional problems, his problems in business, his problems in his firm, and it slowly led to when they showed up at his office, he was in a panic, and he fibbed. He made it up out of whole cloth. And he admitted it, if you notice, when I was involved with him in both the formal complaint, and he admitted it in the stipulation. And then he got on the witness stand and panicked again.
In the panel hearing? Because I would
Correct.
say that wasn't his story in the panel hearing, it was an entirely new story.
Absolutely, I don't disagree with you on that. I'm telling you, it happened again. He panicked again. When he's led by the hand and you're there with him, he was able to do it, but he got on the stand and he froze up again. It's a tough argument. I didn't want to be here today to make this argument, but that is the argument, and that's all that I have. I'm not a fool. I understand how serious this is. We all understand that. Everybody is here, and everybody can hear this and knows how terrible this is, and this is what we preach against all the time. Be honest with the disciplinary administrator's office. And I'd like to think that all of us would be, and all of us would answer that way. And I'm not a psychologist. I can't explain why this man did what he did.
How could we justify a 1-year suspension when in other contexts people go to prison for lying under oath?
Some people do go to prison for lying under oath. I'm
just
saying,
asking for your best justification for...
My best justification is he panicked, and that's an excuse that if it was in a criminal trial, you can argue to the jury he made a mistake, he panicked, he got scared. And it's argued all the time in those type of cases.
Just so I understand your argument, counsel, your client does not have any intention of ever practicing law again. That's why he's closing his doors, but for his own reputation, peace of mind, he preferred not to be disbarred. He wants something less than that. Did I
I don't think
misunderstand?
that's correct. I don't think he'll ever practice law again. I think he's going to try for another career. He's closing his doors because we've had conferences where I've told him, this is what's going to happen to you. You're not going to have a license. So he's been closing his doors. He's been advising his clients. He's not taking any new clients. He's not taking any fees. And you know that what happens in this room sometimes, some of the people that I've represented over the years keep bringing in the money, keep practicing law, and it's not until they get that decision on a Friday that they finally close it down, and then there are people without money, there are people without representation. He is referring people out. He's not making new clients. That's what I'm saying. I hope I answered your
You have. thank you.
question. With your permission, my client would like to address you.
Certainly.
May it please the court, I'd like to first offer an apology to the court, to the disciplinary administrator's office, to the complainant in this matter. It's been a very difficult last year and a half for me. And suffice it to say that I was never considered myself the type of person to stand before you under these circumstances. I've worked very hard to achieve the successes that I've had. I've been licensed by this body representing the individuals of this state since 1982. And I've gone decades without any problems whatsoever. I'm very proud of my accomplishments, my career, my position in my community and my church. And I was humbled and overwhelmed by the support I received by fellow attorneys and judges when asking for their support with regard to this this issue. I would ask the court to understand and remember that how difficult private practice is for sole practitioners and for attorneys in small firm situation, and the daily challenges are extraordinarily difficult to maintain a perfect record. It's very difficult for me to be here today. It's very embarrassing. It's humiliating. One thing I do want to point out throughout this process, there's some confusion regarding the facts and how they're presented. I first of all want to say this is entirely my fault, okay? And that attempt was made at our panel hearing, or whatever it's called, the hearing I had for the disciplinary administrator, and that there was just a discrepancy in the facts that were presented. And there were some questions that were asked of me were those of first impression. And in the confusion of the process, it was never my intention at that stage to alter those facts or whatever, but I simply wanted to explain what really occurred. But I want it made clear at this point that it's entirely my fault. And that what I did was wrong, and I understand that discipline is appropriate. And I also want you to know how hard and how difficult it is for me to say that and understand that, because I don't consider myself the type of person that would do something like that. I know I'm not perfect. I know that I have issues and problems professionally and personally that culminated together, and that perhaps the confluence or the perfect storm, the terminology Mr. Ambrosio used, caused me to take the actions that I did, and I extend deep regret. I know and understand the consequences for that. What I want to do is I would like to seek redemption in some way. I would like to prove myself to this court, to the people that you represent, that this court represents, that I would like to give myself a chance to prove myself and to have some sort of redemption, that someday I could again have my license to practice law, and that I would finish what I consider a very proud and, I guess, distinguished career. I would like to finish that, and I don't want to surrender my license. I don't want to stop doing that. I ask this court for your forgiveness of my action, and that I would like to point out that the recommended discipline by the disciplinary administrator's office is the same that this court would issue for someone who's committed a very serious crime, such as a rape or murder, someone who's stolen money, converted money from a client, or has been involved in drug usage or sale. And I would ask that the court, to indulge you in the fact that my action doesn't rise to the level of these serious crimes and these other actions. And I would ask for the consideration in that regard, and perhaps some leniency if you feel that's appropriate. I have no further statement.
Any questions of either counsel? Thank you both. You reserve 3 minutes.
Just briefly to answer your question, Justice Rosen, it's on page 23 and 24 of the transcript. The claim went to arbitration against Commerce Brokerage, and it was settled for $20,000.
That's how I remember seeing 20.
Yes. Ms. Simmons ended up with $12,500 because her attorney's portion of the settlement was $6,666. The original amount, she owed the IRS $52,000, and she owed the state $7,000. And lastly, just in closing, I would note that although Mr. Williams asks for leniency and says that there was a discrepancy in the facts and says it was his fault, he still hasn't said exactly what he did with the letter. He has not told this court exactly what were the real facts. He said there was confusion, but what were the real facts? our recommendation remains the same, and we ask that the court enter an order of disbarment in this case. Unless there are no other questions, I have nothing further.
Any questions? Thank you, counsel. We thank all counsel for your arguments this morning. Court will take this matter under advisement.